In my practice, I often get that phone call. My dad died, and he named me the executor in his will. What do I need to do? When you have been named the executor of an estate, it is critical that you act promptly. I can't tell you how many times a client has approached me with an estate that should have been easy and relatively low cost to administer, but then I find that the death certificate is dated several years ago. Unfortunately, now that estate will likely be difficult and expensive to administer because it's going to be hard to obtain the documents that we need. If you act promptly to complete some key steps early on, your job will be much easier as an executor. One of the first things you need to do is make arrangements for the decedent's mail to be collected regularly, and then review the mail in a timely manner to avoid potential issues. You don't want to sit on mail for weeks at a time, otherwise you could miss deadlines for tax bills, insurance payments, or notices of inactive accounts that will be turned over to the state as unclaimed property. We need to make sure that the decedent's assets remain intact and insured during the estate administration, and that you continue to collect account statements and any bills or debts that are due to be paid. When a person dies, oftentimes there may be outstanding medical bills, unpaid credit cards, loan and mortgage balances that are due. You should never pay anything beyond funeral expenses until you consult with an attorney. If a decedent owned more than $100,000 in assets in his or her individual name, then probate may be necessary. In this case, those people and the companies to whom the decedent owed money don't get paid for a period of 6 months. Even if final notices are sent and collection agencies get involved, you should not pay anything until your attorney gives you the go-ahead. There is a legal process that must be followed that prioritizes which creditors get paid first and whether they get paid at all if an estate is insolvent. The next thing you want to do is try to locate the decedent's estate planning documents. The will, any trust documents, a designation of a guardian if there are minor children or dependent adults involved. If the decedent did have an estate plan, then you will want to consult with an estate planning attorney to interpret exactly what the documents say and who the estate's beneficiaries are. This may include individuals, groups, trusts, or charities. I've had many clients tell me that they have read through different documents and they thought they had the gist of what the documents said, but later we found out they had missed or misinterpreted one or more important key legal points. Your attorney can help you with that process, and if probate is necessary, your attorney can represent you and the estate in required court proceedings. You also need to go through the decedent's records. An executor needs to gather all financial statements, income tax returns, life insurance policies, homeowners insurance policies, property deeds, and vehicle titles right away. These documents can provide important clues that help with determining the ownership of the decedent's assets, any named beneficiaries, and whether probate must be opened. I suggest putting everything in one envelope or a folder to keep an inventory of the decedent's assets and debts. As you review, keep an eye out for anything that identifies beneficiaries for retirement accounts, insurance, or other accounts. Any assets that have designated beneficiaries are not subject to probate. In most cases, they can simply be transferred or dispersed directly to the beneficiaries during the estate administration process. It's worth noting that as important as it is to identify beneficiaries, it has been my experience that it's even more important to manage the expectations of the beneficiaries from the start. Lots of times beneficiaries will approach an executor and say, "So where's my share of the estate? When am I going to get it?" That answer may actually be 1 to 2 years from now. Beneficiaries need to know up front that they are often the very last people to get paid from an estate. Probate and estate administration processes are complex and simply take time to complete appropriately. You want to communicate with the beneficiaries early and often. The more direct and transparent you can be, the more informed and comfortable everyone will feel. Another important step to take early on is to contact the decedent's accountant to confirm whether all taxes have been paid and to make sure the next tax return gets filed on time to avoid penalties. The accountant can also help address tax issues and any questions that may arise during the estate administration process. Many of my clients seek the advice of an accountant when making decisions about the transfer of inherited retirement accounts to avoid unwanted tax consequences. Next, you want to get several certified death certificates from the funeral home. I usually recommend my clients get at least 10 to 12 certified death certificates, or more if the decedent had a lot of assets. Most insurance companies, banks, and other companies will require a certified death certificate be provided in order to secure and administer the decedent's assets. There is less hassle and cost involved when you obtain these from the funeral home early on, rather than having to get them from the county. Lastly, when you have been named an executor, it is incredibly important that you keep complete and detailed records. People will have questions for you later, whether it be beneficiaries, the judge, the accountant, or others, and oftentimes they are entitled to get answers to their questions. I've seen many executors become the target of legal actions from disgruntled beneficiaries simply because they weren't responsive, organized, or efficient. If you keep good records from the start, then you will be able to administer the estate with confidence. If you plan to accept payment for the time you spend completing executor duties, then you will want to create a time log to document it. This doesn't have to be fancy. You can use a notepad or create a table and simply list each date, the work you performed, and the amount of time you spent on it. While all the tasks covered here are important, there are many more responsibilities an executor must perform to administer an estate. The good news is that you can hire an experienced law firm to complete most of the heavy lifting for you. By working with an attorney who knows the ins and outs of tax, estate, and probate laws, you will save yourself a tremendous amount of time, stress, and worry, and ensure that you don't make a costly mistake.